Sweet. Okay, it says it's recording. Are there any other administrative woes that we're currently confronting, problems, thoughts, issues that you wanted to square away? No? I have sent you out a few emails today. Firstly, for the benefit of those that don't check their university email account terribly often, it seems to me that there are quite a number of you guys that haven't actually purchased the text. I would highly recommend that you do so, particularly in relation to your knowledge of the IP rights, as you need to set it out for the end of semester written assignment. That particular assignment requires a fairly high degree of familiarity with the various different IP rights before you can sensibly set out your ideas on, you know, the shortcomings of the relative systems or, you know, the need for reform. And I'm just a little concerned that if you guys leave it to the last moment, I mean, the whole reason why I've structured the unit this way is to give you this kind of breathing space at the beginning of the term in order to get your head around all the various different IP rights. And then at the back end of the term, you know, you're then in a position to, with a relatively high degree of, I don't know, mastery, if you will, then go about your critique in your presentation and your written assignment there and your end of semester assignment. Googling and looking just at the straight legislation is only going to get you so far. It's not going to necessarily provide you with that nice compendium of case law that is summarised in the Fitzgerald text. So I would encourage you to either get your hands on a copy of the text, or if you have somebody that has, you know, a relatively recent IP text that's, you know, academic and robust, then, you know, shoot me an email and say, can I please use this instead? And, you know, chances are that you'll be all good. Or if you are lucky enough to work at a firm and the firm has subscriptions to loose leaf services, a lot of the loose leafs will have a reasonable amount of detail on IP. So it's probably, now that it's week 3, I'm just cognizant of the fact that we're going to have to start getting our heads around, you know, your presentation and your end of semester assignment. And I wouldn't necessarily be kind of lulled into a false sense of security with the end of semester assignment, even though it's not due for ages. It's probably a good idea for you to start just slowly, even now, chipping away and gathering a few different research resources in relation to your end of semester topic, because particularly for those people that are looking at, for example, presenting in week 11, you've only got just a very short time after you've presented and submitted the paper that you need to submit after your presentation, before you actually have to submit your end of semester work. So do bear in mind that time frame. I have set it up so that you have, you know, a fair bit of leeway at the front of term to get your thoughts together, get your understanding of the IP rights together, get it up to a certain level such that then you can kind of almost stand on the top of the mountain and look down and critique it with a nice kind of precise level of familiarity with the IP rights, so that you can be making some, you know, wonderful comments that will make me go, I haven't really thought of that before. Okay, so just a bit of a nudge to get yourself organised. Now, In that respect, I do want to mention a couple of things. Firstly, I have had one group suggest to me that they might like to change their presentation topic. Now, I am open to that, but you're going to have to, if you're going to do that, you're going to have to get it all squared away with me before Monday of week 4. Okay, so you're going to have to get your collective thoughts organised, write me a nice paragraph on your proposed hypothesis and your proposed conclusion, and some of the points that you'll be making, so that I can see whether it's, you know, a robust enough topic to present for an hour on. That all needs to be to me kind of ASAP, all right? So if you're going to tweak that presentation topic, I need to know about it sooner rather than later. The other thing is the 2 topics for the end of semester assignment are already in the week 1 materials. As I say in the week 1 materials, I'm more than happy for you to also put your own spin on either of those topics. But again, I need that your proposed changes or your proposed hypothesis and your conclusions that you're hoping to draw to me in writing no later than Monday of week 4. Okay, so you do have some options in terms of pursuing things that you find of burning interest to you. However, I need you to get your thoughts organised early so that we don't run into problems, you know, after the break and then all of a sudden everyone's running out of time. Okay, I'm just doing a bit of finger wagging here so that you kind of, so that you get your timelines organised, all right? Any other problems, queries, issues that we need to address? Nope. All good. What I will do then is I will share my screen and I will get us to, hopefully, where are we? There we go. All right. I will get us to our, wow, problem for the Zoom sessions. Okay, so here we are back at Nigel and Roy. We know that, oh, hang on a second. My little, here. I'm pretty sure I'm still recording. Just let me stop the share for 1 second. I just want to make sure I'm still recording. Yes, I am. Good. I have this constant nagging fear that I'm going to be not recording. Okay, so we're back with Nigel and Roy. We know that they have problems in terms of their logo and their slogan, and there's some copyright stuff that's floating around there. What I do want to draw your attention to here is that they did actually use 11 secret herbs and spices in their burger meat. They hadn't revealed the combination to anybody outside of their operations. They put it all into a manual and they claimed copyright over that. Well, we talked about that last week. Also, Roy had developed this burger flipper tool designed not to break up the meat patty while cooking. He'd applied for a patent. He's already gone ahead and filed his complete specification. And then down here, we run into problems with Fred. Okay, they employ Fred. It's all done with a wink and a smile, and unfortunately, no actual employment contract. He was only a part-time manager, so he probably was not terribly senior in the organisation. Obviously had access to the recipe, gets all of this goodness, all of this knowledge and, you know, trade information from working there, and then runs across the road to set up business in competition. All too common a scenario. We note that he replicates Roy's burger flipper easily, okay? His business immediately impacts on Nigel and Roy's because he sells his burgers more cheaply. All righty, let's do some preparation work, shall we? Differences between a standard pattern and innovation pattern. Now, this becomes relevant when we're talking about Roy's burger flipper. So what's the term for a standard pattern? Anyone?
20 years.
Yep, that's it.
I don't know what section that's under though.
That's right. It's in your IP Ready Recna.
Oh, yeah.
67, section 67.
Nice one. Nice one. So the term for an innovation patent is?
8 years.
Thank you, Joselito. Nice to hear from you. 8 years. Okay. What is the reason for the difference? Anyone tell me? What's the aim of an innovation patent? What's the whole point of an innovation patent system? Anyone?
It's effectively a work in progress. The product isn't finished and it's still being developed. So you're sort of stopping anyone developing your idea further.
Well, I would say that kind of commentary applies more to the issue of filing a provisional patent specification, because that usually is a work in progress. And you have 12 months from filing your provisional patent specification when you apply originally for your patent. You have 12 months to develop the widget, whatever it is, and then you must file a complete specification within 12 months. Okay, and by that time, the widget, whatever innovation or invention it is that you're filing for, needs to be settled, and you need to know the best method of use because you have to disclose that in your complete specification. So that's where the issue of a work in progress kind of comes in. Innovation patents aren't necessarily a work in progress, but what they are is usually just some kind of incremental improvement that somehow makes the widget perform better, do something faster, cheaper, easier, more conveniently, and that kind of thing. So you're looking at these little itty-bitty steps in terms of making something better. So really what you're applying for is protection just for that little improvement, if you will. So it's really a quick and dirty kind of a system that lets you get protection cheaply, easily, but it's really designed just for those kind of baby step inventions. Okay, so as a result, examination with a standard patent takes years and years and years. The examination process seems like it goes on forever. It can happen in as little as about 18 months, but if you're unfortunate, it can go 3 years or more. Okay. However, for innovation patents, what's the go with examination there? Can you tell me? Quick and dirty process, I said it was. And this is a very quick and very dirty process.
1 month?
It's not even that, Jacob. You know what it is? They check to see if you spelt your name right, and that's about it. Honestly, they do what they call a formalities check. They certainly check to see if you've paid the correct fees, And apart from that, you're all done and dusted. There's actually no examination that goes on of the invention itself or the innovation itself. If you want that, you have to then go through a certification process. And that is much quicker than a standard patent. It's a bit of, you know, how long is a piece of string? It'll depend on how many applications are all in the mill at the same time. But I believe it was somewhere around 6 months or less. I'll put a question mark there because I haven't checked for a while. Now, the thing is, if you don't get your innovation patent examined, can you actually use it to threaten people with? Can you say, please stop using this widget because I have an innovation patent, and threaten to sue them? Thank you. Jacob's shaking his head. Yes, just Joselito's also shaking his head. No, with innovation patents, you need to have it examined first. Okay? So either you go the full standard patent and you go through that laborious process, or you go the quick and dirty option, but just bear in mind you can't enforce the thing until you've actually had some level of examination. All right? We'll talk about, if we get a chance to talk about reform, we can talk about reform after we've actually looked at the problem. The benefit of innovation patents really is just, you know, the quick and dirty nature of things. You can get some protection fairly quickly and fairly painlessly. Can anyone recall who takes out innovation patents most often?
Australians?
Yes! Thank you, Bianca. Australians are the overwhelming recipients of innovation patent. And what about standard patents?
Mostly overseas people or businesses.
Yep. And of those, a very large proportion are American. Okay. Alrighty. We need to know whether Roy can get a patent on his invention. What are the two issues that we need to satisfy to see if it's a manner of manufacture? And this is the NRDC case. National Research Development Council and Commissioner Patents. Patents. It has to be an artificially created, anyone? Got any ideas? No. Okay, artificially created state of affairs. So you cannot try and patent a new mineral that you've found, okay? You cannot patent anything that is of itself a product of nature or something like a pure mathematical algorithm. That's really getting very close to just pure information. You can't, you must have invested some kind of human ingenuity to make this invention happen, okay? Artificially created state of affairs of some kind of use in an area of economic endeavour, okay? So it's got to be economically useful. So compare it to copyright, where you might create an artistic work just for the sake of your passion for creating artistic works. It might have zero economic use. Well, I know my artistic work would have zero economic use, but you're still going to get copyright protection. Here, very targeted requirement here for you to have what we call a patentable manner of manufacture. Okay? Now, if you look at the video for this week that I did on patents, you will see that the Darcy and Myriad case that came down 2015 added some extra considerations. Now, these considerations were added because of the particular nature of the invention that was at issue in that case. Can anybody tell me what was the invention that was at issue in that case?
Is that the one about somebody trying to patent the breast cancer gene?
Yes, thank you, Bianca. Yes. And as you can immediately spot, an invention like that is going to be extraordinarily controversial. You're going to have somebody like Mrs. Darcy, who was a cancer sufferer, and she, the problem with Myriad's patenting of that gene was that they demanded that all BRCA gene testing in Australia be done by their exclusive licensee. Okay? You can't afford that licensee's costs, and I can tell you right now, I've had it done. It's about $1,700. You don't have access to the test. Now, there was some talk about the exclusive licensee not enforcing their IP rights here and allowing public authorities to continue testing. The public authorities basically just were thumbing their nose at the IP rights consistently for about 8 or 10 years until this all came to a head and came before the courts. So I will leave you guys to look at the video for this week and work out the additional considerations that a court might apply where it is a particularly controversial manner of manufacture like that one. Can anybody tell me, just before we leave that, what the conclusion in the Darcy case was? Were the BRCA genes patentable subject matter or not? Anyone?
No, they weren't. Purely on the condition that the court felt it was a legislation issue, not a judicial one.
Yes, exactly. And I think these extra kind of caveats, if you will, really needed to be outlined by the High Court purely to keep this old NRDC case. That's a case from 1959. So that stood us in pretty good stead for a whole stack of years in terms of allowing the patent system to cope with new technology and completely new kinds of invention that weren't even contemplated in 1959. I mean, this simple two-pronged test that came out of NRDC has been pretty effective and pretty, consistent with keeping us within the bounds of what should and shouldn't be patentable subject matter. But where you've got now things like gene testing, genetic modification, you've got chimeras being created, human-animal chimeras, all of this kind of technology wasn't even a glimmer in a scientist's eye in 1959, except, well, maybe if they watched some kind of, science fiction program. So I think the Darcy case was timely in adding some extra considerations to that NRDC test to allow courts the wriggle room that they need to say, look, this is a whole new area for us. There's a whole lot of public-private conflicting interests going on here. It's really something that needs to be decided by the legislature. Okay? So that's the kind of updating alert for you guys in terms of the NRDC case, because the text does talk about the NRDC case, and you guys need to be aware that it has been amplified with these extra considerations as a result of the Darcy case, and the Darcy case came down just after the text was released. Okay, so you need to kind of put a little exclamation point in your text like I do, scribble all over it, and just note the Darcy case there. Novelty. What's the point of novelty? What's the point in requiring that something be novel? I mean, we don't require that copyright works be novel. This is what we were talking about last week. Novelty. What's the point of that? You're giving the patentee an exclusive right to exploit an invention. You need to ensure that the patentee isn't trying to exploit someone else's earlier idea. The whole idea of the patent system is that it's a reward for invention. There's no point giving a 20-year monopoly. I mean, it's not as long as copyright, 70 years, but it's a very, very strong and scary IP right. It's probably the strongest of all of them and the scariest. Okay? You do not want to be giving out this thing lightly. It has to represent cutting edge, unique and new technology, okay? You're not just looking at somebody else's old ideas. It's something new that you've come up with, okay? Inventive step. What's the test for inventive step? Can you tell me? It has to be to a non-obvious to the good old person, I call them the PSA.
I was going to say the expert, so it's not the next logical step for an expert to make.
Absolutely. Thank you. Thank you, Bianca. Yes. Non-obvious to the person skilled in the art. And that's just a term that gets bandied around in the relevant case law, okay, so, and in the legislation. Person skilled in the art is the relevant expert in that particular field of technology or invention, okay? So it has to be non-obvious. So here we are looking at a clear departure from the likes of an innovation patent, which simply says, now, I can flick over to it here, I think, because I think yes, I do. Can you all see the Patents Act there? So I've highlighted section 4 there for you. This is innovative step as opposed to a full-on inventive step. Look at the lowest standard here. So both of them, both section 2 and 4 say an invention is taken to involve a relevant step when compared with the prior art base, unless the invention would, now up here we've got have been obvious to a person skilled in the art in light of common general knowledge, and down here we've got person skilled in the art in light of common general knowledge and it would only vary from the kinds of information set out in subsection 5 in ways that make no substantial contribution to the working of the invention. And there's your little get out of jail free card, okay? That's what makes it so easy to get an innovation patent. Because as long as you are actually doing something that contributes positively to the working of whatever invention it is, then you're going to have sufficient innovative step, okay? Test is stricter for inventive step. It's got to be non-obvious to that relevant person skilled in the art, okay? Utility, what does that mean? Can the invention be, let's compare it to copyright again. Can it be something beautiful that you look at? What's the point of utility? Ties back to this notion in manner of manufacture of it being of use.
Yeah, I guess it must have some industrial application.
It must be useful, and that use must be specific, credible, and I think it's specific, substantial, credible. Okay, so you can't just say, oh, yes, it's useful and not provide anything to back that up. And here we had particular problems in the early days with genetic inventions. Okay. Our requirements of utility weren't as stringent as they are now, and you had a whole stack of patents granted over various different genes with not a whole lot of evidence to support the fact that this was actually going to be a useful invention. And this is one of the areas that's been tightened up specifically to weed out all of those bulk of patents that were granted that weren't perhaps necessarily as useful as they should be if you're going to get a 20-year monopoly. No secret use. What does that mean? Why is there that requirement there?
Yeah, I guess because if it is used before secretly, then it's prolonging the monopoly of the person.
Yes, Oslito. Exactly. You're getting more than a 20-year monopoly then, aren't you? Whoops, I said the M word. I don't necessarily think it's a monopoly, but yes, that's absolutely right. You're extending your term of protection, because what you're doing is you're getting the thing out there, you're keeping it secret, but you're earning money from it, most likely. And then you're applying for a patent. And because you've kept it secret, it's still technically novel. And then you're getting your extra 20 years. You're kind of, double dipping. Okay, so no double dipping needs to be, the application needs to be filed first. And that's particularly the case if you ever get any clients that are researchers. You need to impress on them the importance of keeping that invention secret until you get a chance to get that application across the doorway of the Patents Office. I've had too many dealings with clients that get so excited about their invention, they just go out and tell the world, they publish an article, they talk at a conference. There is a protection for that to a limited extent. There's a small grace period. So where you've actually mucked up and you've disclosed the thing, if you can hurry up and get your application within a relatively short time frame into the Patents Office, they'll forgive that disclosure. But you have to comply with the grace period requirements. Other than that, every disclosure will be a destruction of the novelty requirement. Okay? Alrighty. So, do we think that Roy could get a patent? for his invention. Where is the big glaring problem in Roy's invention? And bear in mind, he's applied for a full standard patent. Okay? Where's the glaring problem? I've outlined it in green.
It's been replicated, so it's not new. It's not a novelty.
Well, he's already filed the application. So novelty is assessed as at the date of your application. So we are assuming that when he filed the application here, had applied for a standard patent, okay? We're assuming that that takes place first. So they're assessing novelty from then. I'm thinking...
Maybe it's not that kind of unique or out of the common knowledge of people.
Bingo! Absolutely. So you're looking at an issue of obviousness here. Okay? Remember in the video I say, if the ordinary person skilled in the art would think, what's a good way of doing this? And could put one and one together and make two, then it's not going to be the kind of inventive step that's going to support a full standard patent, is it? So that is where I think we would have problems for Roy. I'll just go down here. Roy's invention seems to have been replicated easily. Query whether it would have been obvious to a person skilled in the art. And particularly, I mean, given that Fred is only a part-time manager, we're assuming he hasn't had any particular training in, you know, constructing burger flipping implements. So even just as a matter of common general knowledge, it seems to have been that he's able to replicate this thing. So I think there would be the natural place for Roy's application to fall down. Okay. In terms of, has anyone got any queries on that lump of stuff? All make relative sense? All right. Let's look at know-how. All right. What's the big problem here with their know-how in their manual? I'll just flip back to the actual facts here. Nigel and Roy employ Fred. He's only a part-timer. He gets access to the recipe. All of that good stuff goes into his head. He runs across the road and sets up a competing business. Okay. Let's flip back down here. What's the problem here? How did Nigel and Roy engage Fred? By a lovely 3-page contract, well drafted by a graduate CQU. For a very competitive price, I'm sure. $100 per hour.
So I imagine that the lack of contract for a start is a big mistake because there's no confidentiality clause or anything like that included in it.
Exactly.
So,
exactly. Often this happens, you know, people are so excited to start their business and get operations underway. Fundamental issues like this get glossed over and lost. So no contract to employ Fred. There's your big first problem. Now, let's say we are looking at, obviously there was a verbal contract. That doesn't really help us a whole lot because the terms and conditions will be contestable. And it doesn't seem, even from the information from our client, that there was any attention given to confidentiality, verbally or otherwise. Okay. If there was a contract, there are still problems. What are the problems that were outlined by the Magbury and Haffield case? It's outlined in the text. One of the big questions there, can you protect indefinitely? What's the answer to that one? I might just pop that on a different line. Can you protect indefinitely via contract?
I don't believe so. I haven't actually read the text yet, and I'm not aware of that case, but I think you can write a certain period after termination of the contract or employment ceases. I think it might be 3 years generally or something like that. That jumps out at me.
Lovely. I know that I can see the bells ringing in the back of your head. Can you delve back into the recesses of your mind and tell me what the doctrine is? It's the doctrine of restraint of trade. That's it. That's what's ringing bells for you. Yeah, absolutely. Nice one. I do like to see where you make connections between this unit and what you've learned in other units. Probably I would hazard a guess in contract B, all those years
Employment law.
Employment law, good. Okay, so no, you can't, because of the doctrine of restraint of trade and its requirements of reasonableness. And you're right, 3 years is usually the rule of thumb there. In the Magbury case, they had a confidentiality agreement. However, the party that was requiring that the other party not disclose had in fact already disclosed. Okay, so if the information gets into the public domain, particularly by the discloser, by the discloser, then you can't prevent the other party disclosing or using. Yep. If you put it out there, you can't complain then if the other party to your agreement says, sweet, that's public domain information. I'm going to use that to my heart's content now and I'm not going to actually pay you anymore. Okay? Case law, Magbury, doctrine, restraint of trade. Now, in terms of implying an obligation of confidence, you're going to try and have resort to the business Cassie here. And when can you imply a term for the purposes of business efficacy? Ooh, contract. Implied terms. It needs to be implied to make the contract work or provide the benefits intended. Yep. You don't need to imply an obligation of confidence here. He could do his job perfectly well. He could get paid. There is nothing that would rob the parties from the benefits intended, is there really? Okay. Terms can't be implied. Okay. Actions, could they then sue Fred?
AJ, I got a question.
Yeah.
Yeah, what if what's his name again? Fred, aware that the information is confidential and then he used that for his own purpose, would that an element of breach of confidentiality?
Yes. So that's what we're looking at here. Because there's no contract, you are then thrown onto, and you know what? If you're going to try and enforce anything against anyone in relation to confidential information or trade secrets, you want to be able to rely on the beauty of contract law. You do not want to be thrown into an action for breach of confidence. And this is what we're getting to now. Sure, it's available as a last resort, but man, there are so many questions in this action that really are all answered by, you know, how long is a piece of string? And it takes so much evidentiary time and money getting something like this across the line to court, let alone, and some of the case law, you know, you really feel for the people that are trying to keep their trade secret, because at the end of the day, they're probably down, you know, a couple $100,000 or more, and at the end of the day, you know, they get no protection in many, many cases. They fall down on one of the elements here. So this is not the thing you want to be thrown back on, but if we had to, requirements, you need to have the information possessing the necessary quality of confidence. Okay, if it's already out there into the public domain, widely known, widely used, it's not going to qualify for protection. Okay. You have to show that the information was imparted under an obligation of confidence. And here you need to show that the person you disclosed to knew that this was confidential information and knew that they were under that duty of confidence. Okay? This is not an easy step to get over, all right? Particularly because, as we'll go down and see with employees, it can be really tricky. You've got to show that there's been unauthorised use that is likely to be of detriment to the disclosure. And the relevant case law here is Coco and Clark Engineering. And additional points were added there. I will leave you to look at the text for those two additional points. But I'll say a brief word about this additional point. This is where you find many cases falling down, and it makes you want to cry for the person that could easily have protected their information by contract. Information has to be identified with a sufficient degree of particularity or precision. And here there is just endless scope for argument about what exactly the information is that you want kept secret, okay? Oftentimes when you have complicated research, some of those research inputs will be public domain, some of those research inputs will be known to some people but not widely known. Some of the research inputs will be quite secret and novel, okay? And it can be very difficult, particularly with complicated information like that comes out of a research process, as to exactly what you can ask for protection for and what you can't. You can see the thicket there, can't you? You can see the potential for endless dispute, okay? And Dunford, that should be, must be reasonable to impose the obligation of confidence. Alrighty. Here's another area for endless dispute. Does the information have to be absolutely secret before you can protect it with this equitable action for breach of confidence? Does it have to be protected, you know, in an ironclad fashion?
I would think not, as long as the people who know the secret are approved, I guess, by the inventor, I guess.
Yeah, yep. Again, this is another area for dispute. You are not required to have absolute secrecy. It just must not be widely known. And there are a number of different questions that courts look at, including the court in Australian Medicare. Is the information widely known? You know, then you have to go about proving how many people know this thing. Who disclosed it? Was it the actual person that generated the trade secret or generated the confidential information that disclosed? How did they disclose? Did they put a widget, an invention, out into the marketplace and then people just went, sweet, we're going to reverse engineer that thing because it's easy to reverse engineer? You can see what I mean. That involves some degree of implication on the disclosure that they should have been more careful with what they did. They look at things like, did the disclosure invest time and money in generating the trade secret or confidential information? And then the courts kind of, you can see, wandering into that area of, well, how significant is this information? Do we really need to enjoin another party from using it? What is the properties of this information that the disclosure has developed? How much time, how much effort, how much money has gone into this thing? And as I think it was Bianca noticed before, they also look at things like what steps did the disclosure take to protect that confidential information? You know, as I said, did they just shove the thing out into the marketplace and hope that no one else reverse engineered it? Or did they actually take steps? Did they put password protection on their files? Did they encrypt their files? Did they have some kind of security system in relation to the physical property in which the secrets were stored? Did they advise people that this was confidential information? Did they generate contracts that had confidentiality terms and conditions in there? Okay, so we're looking at how carefully the disclosure protected what they had generated. So all of this stuff, as you can see, look at the endless questions you've got here. You can see how many areas there are to fall down in before you get this thing across the line, can't you? It's just going to take a whole lot of money and time and make some barristers very happy. Now, the further difficulty we have here is that Fred was an employee. Okay, yes, I guess we can answer these quickly. Is the information widely known? Well, no. Who disclosed? Well, no one's actually disclosed. Have they? Fred's just using it. Now, that would satisfy this requirement here. It had the necessary quality of confidence. It was imparted, well, who knows? They might fall down on the second point of having not made Fred aware that this was terribly confidential. But here's your third point. Obviously, the use is going to be of detriment. Okay. I think we'd probably fall down on number 2. Okay, in terms of Nigel and Roy. Now, here we have, I was just going to say before, an added complication, and that's employees. Okay. There are a number of different kinds of information that employees can inherit as a result of their employment. And they fall into principally 3 different kinds of information. Information that's easily accessible by the public, stuff that's out there in the public domain. Information that you have to treat as confidential during your employment, okay? Don't tell anyone else while you're here. But then, and this is a step that is fought over endlessly in the case law, okay? The employee will undoubtedly argue that this is the kind of confidential information that once you know it, if you want to keep working in that industry, really, you're going to have to take that confidential information on board as part of your then, if you will, common general knowledge as a person in that industry. Okay? It's going to be too hard to divorce that particular confidential information from your duties and responsibilities in a different job. Okay? That's a sucker of a step to fall down on. And then you have the real genuine trade secrets. If you're working at Coca-Cola, I mean, I went to the Coca-Cola head office in Atlanta in the US, vault a mile wide that protects the confidential ingredients of Coca-Cola and how it's made. Okay, everybody in that facility knows without a shadow of a doubt that that is the holy grail of information, which they must never ever disclose, even if they found it out, which they most likely wouldn't, given the vaults that are, inches thick. Do you know what I mean? So it's not often that you will be able to show this level of protection. If you can, great. It means that you're going to have a very easy time in court. But usually you'll find that the protections taken by the person that generates the trade secret or confidential information are somewhat less than perhaps they should have been, because otherwise the information wouldn't have gotten out. Okay? So are we happy enough here with, so we can see Nigel and Roy are kind of looking down the barrel of not a whole lot of happiness in terms of their confidential information. Okay. Any comments on that? If you think that I'm trying to paint this as a really difficult area of law, you're absolutely right. Read some of the case law, and if you have even half a commercial bone in your body, you'll just see these people flushing their money down the toilet. It's really, it makes you want to weep. So that leads me directly to our commercial thinking. And let's wrap it up because we're 4 minutes past the witching hour. Commercial difficulties with ownership of patents. Now, this is something that I just drop in here because of my horrendous experience with ownership. Okay? Let's have a quick look at the relationship between Nigel and Roy and how they're operating their business. It seems as though they are sole traders, does it not? Okay. They want to get into the burger business. They go about focusing on how to operate the business. They choose a name for their business, but there's nothing to stop you from registering a business name of Hungry Macs, is there? That doesn't suggest that they've incorporated anything. They go about attending to the business, and then we see Roy develops the burger flipper tool. All right, let's say our conclusions on patenting were wrong and he gets a patent on this thing and then decides to commercialise it. What rights does Nigel have to a cut of that profit? Any? Roy has independently conceived of this invention and independently filed the standard patent application. If he gets that patent, that will be his asset to which the business has no rights. Okay? So if in fact Nigel wanted to get out of the business and sell his share, if part of the business goodwill had been increased by Roy's use and commercialisation of this patented invention, Nigel would have no slice of that action whatsoever. Okay, if they had incorporated a company, the situation would be even worse, because the company, as a freshly created new legal entity, would have no interest in that asset whatsoever. Okay, and I have seen businesses go bankrupt because of this issue. Okay, you need to be aware of who owns what IP when you go into the business. And if Nigel thought he should be protecting his interests sufficiently, they would have A, incorporated a company, and B, he would have secured an assignment from Roy to the company of his interests in that patent application. Okay? Otherwise, that business will have no rights to that pre-existing patent application. Okay? I'm just being practical here because I've just seen this kind of thing happen too often. Okay? So you need to square away the ownership issue when you start business, and you need to think about what assignments are required of any IP rights. Okay? Obviously, assignment of IP rights, and I've also talked about know-how, what did we say was the best way to be protecting our know-how? Confidential information, trade secrets. They should have
employment contracts.
Okay.
Employment contracts that deal with confidentiality. Okay, very clearly. And I know you would draft it very clearly because you will be marvellous graduates of CQU, as I said, demanding at least $500 an hour. Questions? Issues? Problems? Happy? Makes sense? It's amazing how by halfway through term though, this will all kind of filter back into your mind kind of by osmosis. And when you come to think about confidential information or patents in a few weeks' time, all of this will have magically solidified, hopefully, in the back of your brain. Fingers crossed. Any questions before we leave each other?
AJ, will you, sorry, excuse me, will you share this document? It's a good kind of refresher to go back to when you're kind of searching through the weeds of IP overwhelm.
Searching through the weeds of IP overwhelm. That's awesome. You could copyright that.
I might do.
I will license it to place into my materials because it's awesome. Sure, I'll whack this up under the week 3 materials. How about that?
Perfect.
Sweet. Now, just a quick reminder before you run away, if you want to just whack up a few comments on perusal, just let me know that you've been thinking about this stuff. It'll go towards your group discussion mark, and it will hopefully also kind of cement things in the back of your mind. Okay? Sweet. Well, have a pleasant evening, and I will see you next week. Bye, guys. Okay.